Hey. All persons having anything to do before the Honorable, the Justices of the Appeals Court, now sitting in Boston, within and for the Commonwealth. Draw near, attendance shall be heard. Now state the Commonwealth of Massachusetts, court is open. Please be seated.
Good morning, everyone, and welcome to the January 18th sitting of the Massachusetts Appeals Court. My name is Mary Thomas Sullivan, and to my right, your left, is Justice Shin, and to my left, your right, is Justice Hodgens, and we will be your panel today. This is a one-case sitting, postponed from earlier in the month, but as with all sittings, the usual rules apply. Each side gets 15 minutes. There will be no rebuttal. You can be assured that we are familiar with your briefs and the papers, and we urge you to get to the heart of your case. And without further ado, we can begin. Is it Attorney Costa? Oh, I should say, by the way, that the case is 22P0542, Dorsey versus RATHBUN.
All right. Good morning, Honorable Justices of the Appeals Court, and may it please the Court. So the essential issue in this case is whether the promissory note at issue is a negotiable instrument subject to the 6-year statute of limitations that exists under the Uniform Commercial Code as adopted in Massachusetts. And for all the reasons outlined in my brief and for the reasons I'll represent today, it absolutely is a negotiable instrument. Each and every part of it is something that is totally within the scope of what the Uniform Commercial Code identifies and defines to be a negotiable instrument. The Superior Court, it ruled to the contrary, and it's respectfully submitted that its ruling is clearly erroneous, cuts directly against the explicit terms of the Uniform Commercial Code and the case law that exists in Massachusetts and beyond. The note contains an unconditional promise to pay a fixed amount of money. That's the essence of a promissory note, and it's very explicit in there, where my client, Paul W. Rathbun, promised to pay Kimberly Dorsey a fixed amount of money by a specific date. That's the essence of a promissory note.
But what about that condition at the end of the note on where it says promisor to make principal payment of $20,000 within 5 days of sale of promisor's other property located at 3 Azalea Street, Lakeville, Mass. Doesn't that make it conditional?
No. That's an acceleration provision. So the Uniform Commercial Code is explicit that an acceleration clause does not make a note indefinite or defeat its negotiability. So, and it doesn't state what types of acceleration clauses are allowed or not allowed. It says that subject to rights of acceleration, and it leaves that to the parties to define what will be the acceleration provision. So in this case, it was the sale of a particular piece of real estate that $20,000 would accelerate and become immediately due. And we have other examples in the case law where sort of maybe an unconventional acceleration clause exists, which I'm not even arguing that's unconventional. But for example, there's that Smith v. Gentilotti case where there was an acceleration clause that provided that upon the death of an individual, the debt would become due, and that was deemed valid. So if a negotiable instrument can say upon the death of a person, there's absolutely no reason why it couldn't say upon the sale of a piece of real estate, the debt accelerates.
But was that the full amount due, or was that a partial amount, as it is here?
I believe in that case it was the full amount due, but the Uniform Commercial Code only speaks to rights of acceleration. There's no caveat there that says that it can only be a full acceleration. There's nothing that says that it can't be a partial acceleration, whereupon, such as the note in this case, upon a defined event, that's an objective event. It's not something, you know, some kind of subjective standard. It's the sale of a piece of real estate, which is absolutely objective and verifiable, that the debt due under the note will accelerate. And it's a portion.
So how would a holder in due course know the status of 3 Azalea Street by looking at the note?
That's why we have our real estate recording statutes, so that the world knows that there's been a conveyance of real estate. And so that's at least as, you know, objectively verifiable as any other, you know, standard acceleration clause that might exist in a note. The note at issue had other items.
But isn't it the essence of a negotiable instrument that you don't have to look elsewhere?
You don't have to look elsewhere for the due date, but for the rights of acceleration, you can refer to some outside event.
As Hodgens's point, is that if it's a partial acceleration, how is a subsequent holder of the note supposed to know that without referring to what you're saying as something that's recorded, a real estate document?
I would suggest the same way that one would know whether there had been a bankruptcy filing. You check the bankruptcy court document. How does one know if there's been a sale of real estate? Check the pertinent registry of deeds.
Right, but is there not a distinction between a full acceleration, in which case there's no amount due once it's paid, versus a partial acceleration?
No. No, not at least under the law as it exists in Massachusetts.
You have a case that says that?
The Uniform Commercial Code speaks generally to rights of acceleration. It doesn't limit them.
That's right, but it also says that it's not an unconditional promise if it's subject to or governed by another writing. So if you have to look at another writing in order to know,
Well, actually, Section 3-106 of Chapter 106, it states that a promise is not made conditional by reference to another writing for a statement of rights with respect to collateral, prepayment, or acceleration. So there is no requirement that rights of acceleration be governed sort of within the 4 corners of the document. And sort of by their very nature, the acceleration is triggered by an event that's outside of the document.
what about the provision for payment of attorney's fees if there's a default? So your friend argues that that makes the note non-negotiable because it's an undertaking in addition to the payment of the amount due.
So that's sort of a collection right that only exists if there's been a default on the note. So it's not an additional undertaking that would trigger the obligation to pay. And so the additional undertakings referenced in the code would be some kind of requirement other than the payment of money that would trigger the amount due. And here we have just the payment of money by a certain date. So if there was some kind of obligation, you know, one can think of different types of hypotheticals. That would make it not a note, but sort of a contractual requirement. Then that would be a problem. But the attorney's fees is just a right with respect to collection once there's already been a default and the note's already due.
Has that issue been decided in Massachusetts, to your knowledge?
No, I don't, but I do know that in the commercial industry, it's extremely standard for there to be rights with respect to collection. So unless we're going to upend the whole way commercial transactions work in Massachusetts, I think it's generally accepted that a typical banknote will have certain rights with respect to the lender in the event of default. So, collection of attorney's fees, default interest, for example. These types of things are generally accepted, and I don't believe they're understood in the world of the Uniform Commercial Code to defeat the negotiability of an instrument.
Can I ask you about the mortgage? So our case law is settled that the mortgage is separately enforceable from the underlying note, even where a claim on the note might be barred by the statute of limitations. So in this case, the judge found that your client was judicially estopped from arguing that the mortgage was unenforceable under the obsolete mortgage statute. So why isn't the plaintiff entitled to collect under the mortgage? It wouldn't cover the attorney's fees, but why wouldn't she be entitled to collect the amount due under the note?
Well, that was a ruling by Justice Muse, I believe, which was an interlocutory ruling, and subsequently, went in the memorandum of findings of facts and rulings on the trial, as the case stated, the judge basically found or ruled that the mortgage wasn't enforceable due to the obsolete mortgage statute.
But he says again that based on RATHBUN's actions during the course of the litigation, he has been estopped from challenging the validity of the mortgage.
I don't think that estoppel would prevent the justices from making a correct ruling on the law. Under the so-called obsolete mortgage statute, it's clear that this mortgage had a due date on a specific date. Under that statute, the mortgage isn't enforceable 5 years after that date comes due.
But if there's a procedural bar to your raising that argument, how do we get around that? The judge clearly found estoppel.
Well, I suppose the remedies of the plaintiff with respect to a mortgage would be to foreclose. It's a lien on the real estate. There's been no foreclosure. There's no argument that
Well, the
they should be able
mortgage
to foreclose.
says that if the property is sold without notice, that they can collect, she can collect on the underlying debt. Lender may require immediate payment in full of all sums secured by the security instrument.
Well, the judgment of the Superior Court was that the mortgage wasn't enforceable. And so, apart from the estoppel argument that was raised by Justice Muse, that was the judge's ruling, and I don't believe that's been appealed in the sense that the plaintiff isn't arguing that they should be able to foreclose.
I don't understand why you're saying that. The judge said that Dorsey is entitled to recover on count 11 because of judicial estoppel.
So on count 11, action on a mortgage, for one thing, the mortgage involves a property that's not owned by any of the litigants in this case at this point. So to exercise the mortgage rights, the plaintiff never amended the pleadings to include the holder of the property that's subject to the mortgage. Paul RATHBUN doesn't own that property. There's someone else out there in the world because the property has been conveyed.
So I want to make sure I understand your argument. Your argument is that if your client sells the property out from under, wrongfully sells the property out from under the opposing party without notice, there's nothing anybody can do?
Well, I think
Because certainly the person who bought the property isn't at fault.
even if
You're saying that there's no recourse for money damages against your client?
Well, what I'm saying is that even if the mortgage was enforceable as a contract, the default on the mortgage as a contract would be subject to a 6-year statute of limitations. So,
Except that you've been estopped by virtue of Judge Muse's order, which was adopted by the trial judge.
well,
Or your client has, excuse me.
well, I would argue that the estoppel that Judge Muse found was not, and the estoppel referenced in the final decision, it's just not a legally valid position for the Superior Court to take because it violates the statutes that govern mortgages. So at some point, it's the role of the court to apply the law to the facts in a fair manner, and that wasn't an application of the law to the facts in a fair manner. The legislature adopted the obsolete mortgage statute. It created a statute of limitations of 6 years for non-payment of a note. It created a 6-year statute of limitations for a contract case. And if you look at the history of the case, where, for example, Justice Muse, he went so far as to incarcerate my client for an alleged fraud in the court. A few days later, the single justice of the appeals court overturned that. In this brief, I didn't focus on the issues relating to that, but it wasn't a fair decision. It wasn't a fair application of the law to the facts. There's no way that it's fair to say that a litigant in court is stopped from arguing the statute of limitations, is stopped from arguing about whether or not a mortgage is valid, based on what was essentially, which is in the record, it's one of the agreed facts. All my client did was, when he opposed a motion for an attachment, he's a non-lawyer, he made a representation to the court that he didn't understand why an attachment was needed because there was a mortgage on the property. And Justice Muse found that was a fraud on the court.
Okay, let me just, I think we understand procedurally what happened, but let me just ask you this. And correct me if I'm wrong, but as I read your brief, you didn't address the estoppel issue at all. Am I correct on that? Or did I miss something?
No, I don't think so. Because, I mean, our position is that my client's not stopped from presenting his statute of limitations argument, which incorporates the note and the mortgage. And this is a de novo review. So under the excuse me for one moment, I only have 20 seconds left. So if I may just finish this point.
Just finish the one
The
thought.
judge's ruling, he said, based on RATHBUN's actions during the course of the litigation of this matter, he has been stopped from challenging the validity of the mortgage. Moreover, Dorsey does not now seek to foreclose and recover title to the property. She seeks only damages for non-payment of the note. According to Dorsey, is entitled to recover on count 11 the amounts due under the note. So the judge's ruling, as I read it, was that this was a recovery under the note, not under the mortgage.
Well,
So-
thank you very much.
Thank you.
Your time has elapsed.
Good morning. My name is James Devlin on behalf of the plaintiff appellee, and may it please the court, I'd like to address this briefly. I take it even one step further backwards, which take it back from this issue of negotiable.
Could you just do this? We're having, your voice is a little bit faint, so if you could hold the microphone
Yeah.
up so we make sure we record you. Thank you.
Apologize for that. So, in taking a step back, coming back from the argument over negotiability, we're really only arguing that issue if it's a commercial transaction. My client sold her residence to Mr. RATHBUN. She wasn't in the business, these are all part of the record, she wasn't in the business of selling real estate or taking back mortgages, nor was Mr. RATHBUN. So to even argue the negotiability part under the commercial code,
Well, where in Article 3 of the UCC does it say that the parties have to be in the business of conducting transactions?
well, it says it in the title, that it's the Uniform Commercial Code.
Right, I mean, that's kind of a general provision, but I mean, there are certainly other parts of the code that speak about merchants. But Article 3, the comment to 3-104, which defines negotiable instrument, says the definition of negotiable instrument defines the scope of Article 3. So why do we look beyond just the definition of negotiable instrument?
Well, as I've always looked at it, trying to determine the definitions set forth in the Uniform Commercial Code is not really prudent, since it wasn't a commercial transaction, which would be governed by the Commercial Code.
Is that what the Premier case says, though? The Premier case also says that the focus is on whether or not it's a negotiable instrument. So you have the comments to the code, and you have the leading SJC case, both of which say the focus is on whether or not this is a negotiable instrument.
Yeah, as your honors know, that Premier case dealt with a commercial transaction. It was.
But it drew no distinctions.
No, but it dealt with two entities that were in the business of that transaction, which was the subject of the case. The UCC does, in a sense, define commercial by what it states about consumer. So it would either be commercial or consumer transaction, and replete in the UCC, the Mass version, such as 3-103, consumer goods are defined, same phrase throughout, primarily for personal, household.
Well, let me give you a quick hypothetical here. So let's say I have a negotiable instrument. I have a check, okay, and I'm the maker of the check, and I make it out to my son. Okay, it's a family transaction. I'm just paying him back for some money. He then endorses it over to my daughter. My daughter takes the check to the bank and negotiates it at the bank. Under your theory, the Uniform Commercial Code is not going to govern any of that because it wasn't a commercial transaction. Does that make any sense?
Well, that scenario doesn't make any sense as you've stated, but that's not my position. The UCC, Massachusetts version of it, sets out a specific section, a specific article for bank transactions. So it says bank transactions are subject here, and I agree that they are. But this is not that type of transaction. This doesn't have a certain article that deals only with this, such as the bank transaction does. It has its own separate article. This is just part of the Uniform Commercial Code, and I would say as to that, it's titled commercial. It's not primary. It is primarily for personal household use, which is said in 3-103, 9-102, subsection 23. It's said again in 9-102-13. It's said throughout the commercial code what's not commercial. And that would be anything.
You have a case, even if it's not in Massachusetts, any case that supports that position? That Article 3 of the UCC only applies to commercial, however you define it, commercial transactions?
I do not, and the reason I don't is because it's a Uniform Commercial Code. I thought that was pretty
Well, I mean,
telling.
your friend cites a number of cases where plainly the parties who entered into the note were not in the business of, selling goods or...
No, the cases, I apologize, I didn't mean to.
No, go ahead.
Cases cited are not about personal, non-commercial. The cases cited are about commercial cases, I believe. They're about business to business or some article that sets out specifically without regard to consumer. I could be wrong. I was wrong once in my life before, but I don't recall seeing those cases being primarily non-commercial. In any event, if we want to treat the private sale, I'm not suggesting you do, but let's say we ultimately determine that the private sale of a person's residence is a commercial transaction or somehow governed by the UCC, as you've gone through with my brother, the negotiability argument, I put it in three different parts of my brief, that it's not an unconditional promise to pay. I named 2, and then I said in the third part of my brief that there are 8 more conditions regarding payment. I would only need 1, but it's not unconditional in my view. I do want to point out just a couple of things. One thing that my brother mentioned in reference to my client not foreclosing on the property, that, of course, was because, or let's just say, it's worth noting that Mr. Rathbun, within 3 months after filing suit, being sued and served in this action, he sold the property. He didn't mention it to my client, didn't give her any notice, and didn't offer a penny from that sale. He got $220,000, I believe, at least in that neighborhood. So there was nothing to foreclose on. When he first appeared before the Superior Court, I believe it might have been Judge Shin, there was discussion of this obsolete mortgage clause law. And Mr. Rathbun represented, and it's quoted in the brief, he knew of nothing that would affect the validity of this argument. And then Judge Muse held a contempt hearing where he admitted that within 3 days of saying he knew of nothing that might affect the validity of that mortgage, he knew that there was something that would affect, or at least might affect, the validity of that mortgage. That's why he got put in jail, first time in 37 years for me in civil practice. And he was, just to make it clear, the appeal of that before a single justice here was not a determination by the judge. The gentleman had already been in jail for 7 days on a civil action. It didn't do anything for me or my client, so I simply agreed that it could end. It wasn't on the merits. I put in my brief about proceeding on the mortgage. We never did proceed on them. I started to proceed on the mortgage, but as my brother is aware, that involved filing against some young couple and trying to foreclose on the property that they had purchased, and it was no longer viable to foreclose on that. But I still think we can go full.
Count 10 for attorney's fees, that derives solely from the note, right?
Correct.
So in order to recover the fees, we would need to affirm, if we were to reverse the judgment on count 1, then we'd also need to reverse the judgment on count 10. Would you agree with that?
If I don't succeed here, I don't
Count 1. No, I'm saying, let's say that we, hypothetically, that we say the statute of limitations bars any action on the note, but the mortgage is separately enforceable. But the attorney's fees derive solely from the note, right, not from the mortgage.
Correct. I would ask the court to look at Chapter 231, Section 6F, which may apply here for frivolity. I really enjoy working with my brother, but this concept that, I mean, it's a tough concept in my opinion. But yeah, I would say that might also be a source of attorney's fees. So I also mentioned in the brief about the equal protection argument. I'll just leave it at that. all sorts of judicial decisions affect defendants and plaintiffs differently based upon the facts. I certainly wouldn't be an equal protection argument, in my opinion, my view. And just based on what is known from the record, that this was a private sale of a residence, not unusual that he secured, that Mr. Rathbun secured, Miss Dorsey secured part of the financing by a mortgage. It's not commercial, it's not an unconditional promise. There's a mortgage that could be utilized, and I won't take up any more of your time. I just ask that this be affirmed, and unless you have any questions, I'm all set.
All right. Thank you very much. That concludes our argument today. Our thanks to the parties and to our court officers, law clerks, interns, and the staff of the clerk's office, and our other staff and administrative assistants.
Thank you. One time I had a trial in the bank.